Hello there. I'm attorney Kelly Longtin, founder of Kelly Longtin Law, and I want to welcome you to our YouTube channel. Today I want to talk to you about legal perils of gift and joint ownership between unmarried couples. Now, cohabitating without marriage is becoming more common in the United States. Among 18 to 44-year-olds, the percentage of adults who have lived with an unmarried partner at some point is now higher than the percentage of adults who have actually been married. When you live with a romantic partner, it may feel as though you share everything. And to some extent, that might be true, legally speaking. For example, there's a trend toward unmarried couples buying homes together. While this might make economic sense, especially at a time when household budgets are being stretched, it can also create some legal complications. Now, gifts that are given out purely out of affection can create unintended consequences as well. This includes gift taxes and the relinquishing of control over the gift once it has been accepted. Your heart might be in the right place, but without understanding gifts and joint ownership, you could be making a decision that you may come to regret. Now remember, decades ago, it was rare and even scandalous for unmarried couples to live together. However, like many aspects of American life, this thought is changing. Over the last 2 decades, the number of unmarried partners living together has almost tripled from 6 million up to 17 million. Among young adults ages 18 to 24, cohabitation is now more common than living with a spouse. Among adults ages 18 to 44, 59% have cohabitated as compared to 50% who have never been married. Since 2002, the share of U.S. adults who are married is significantly down. Over the same period, the share of adults living with an unmarried partner has more than doubled. As marriage and cohabitation trends change, Americans are becoming more accepting of unmarried couples living together, according to research. In addition, some arrangements that were previously only available to married couples, such as car insurance and health insurance, have been extended to unmarried couples. Today, most insurers allow a significant other, a boyfriend, girlfriend, domestic partner, or fiancé to be added to an insurance policy. Sharing a single auto insurance policy with a domestic partner can save both of you money on premiums. However, if your significant other has a bad driving history or they get into an accident on a policy that you share, then that could increase your rate that you pay. As the number of cohabitating partners has increased, so has the number of unmarried couples buying homes together. According to the National Association of Realtors, 9% of home buyers in 2020 were unmarried. Although it might make financial sense to buy a home together, a property that is jointly owned by both partners presents legal risks and obligations to each co-owner. These same risks and obligations can arise if one partner already owns a home or another asset and adds their partner to the title. First, adding another person to the title of a property can trigger gift tax consequences in states in which the joint owner does not have the right to sever their interest. In such states, the gift is typically valued at half of the property's value. If the value of the gift is over the annual gift tax exclusion, which is $16,000 in 2022, then a gift tax return will need to be filed by the person who is actually giving the gift, for example, the original owner. Due to the high lifetime estate and gift tax exclusion, over $12 million in 2022, it seems unlikely that any gift tax would be owed. However, the value of this gift will be deducted from the giver's lifetime exclusion amount at their death. In addition, once a joint owner is added to the property, that property can immediately be susceptible to the new joint owner's creditors. Obviously, this has implications for the original owner if a new joint owner's creditor goes after the now jointly owned property to satisfy any debt. Finally, depending on how the property is titled, unmarried partners who buy a home together could inherit each other's share of the property automatically. This happens when the property is deeded to the new owners as joint tenants with rights of survivorship. Now, there's some alternatives to joint tenancy that do not trigger survivorship options, and that's the owners holding the property as tenants in common. You can also have a trust own the property, with the non-owner partner having a right to occupy the property for a designated period of time. And you can also create a limited liability company to own the property with a retained right of occupancy for the surviving owner. A cohabitation property agreement that protects each partner's property interest should also be considered. An agreement of this type can include a dispute resolution process, an exit strategy, a buyout agreement, and a plan for account and property division if and when the couple splits up. Love can make people act irrationally, as we all know. Somebody might be convinced that they've met the love of their life, and this can prompt them to make decisions that they may regret in hindsight. Look before you leap is good advice when considering marriage. But prior to marriage, you want to think before you gift. Gift has a specific legal meaning rooted in contract law. It's something that is transferred from one person to another for a non-business reason and without any compensation. Now, some of the conditions that have to be met in order for the gift to be valid is the person giving the gift intends to actually gift it. Second is that the giver actually delivers the gift to that receiver. Doesn't promise to do it in the future, but actually delivers that gift. And that the receiver accepts the gift from the giver. If a gift meets these requirements, contract law recognizes it as a valid gift. As a result, the gift is enforceable, and in most cases, it cannot be taken back. That is, once a gift is successfully made, the giver loses control over the gifted money or property. Gifting an object of relatively little value probably will not be a big deal in the event of a breakup. It is unlikely that somebody will ask for a birthday or a Christmas present back so they can return it for a refund. But the gift, if that gift is something large like a joint ownership in a property, major issues can arise. Imagine that you add your partner to the title of your house so that legally half of the house is theirs. After a split, they are unwilling to return their share to you. To get it back, you would have to buy it from them. But what if they do not want to sell it to you? Alternatively, they could buy your share or they could sell their share to another party. They could also petition the court to perform a forced sale of the property and distribute the proceeds among the two of you, or ask the court to petition the property. In any case, these are probably not scenarios you would have agreed to if you had thought through your gift of joint tenancy ahead of time. A house is a dramatic example of the perils of gifting, but the same legal considerations apply to any gift, with the possible exception of an engagement ring. Because it is a conditional gift that is predicated on a future event taking place, the giver may have the right to get the ring back if that future event, the wedding, does not actually take place. However, courts have taken different views of this issue, and it really sometimes just comes down to the specifics of that broken engagement. Even though cohabitation without marriage is more popular than ever, unmarried couples still do not have all of the legal protections that married couples enjoy. You might be certain that you've met the one, and you may actually be right, but before you hand over the keys literally and figuratively to another person or sign on the dotted line with them, there's no shame in talking to a lawyer about how to protect yourself. If you have any questions about how to gift property to your significant other, you can always contact us if you live in Mass and New Hampshire, or just contact the estate planning attorney that you're working with. So I want to thank you for watching. I'm attorney Kelly Longtin, founder of Kelly Longtin Law.